first question, in some respects, and this is for everybody, is what you think about why then? Like, why in 2007, 2008 did Heller finally get resolved the way it was? Because in some respects, the materials of the decision, in respect, as Alan Thomas pointed out, were there all along. There was no new discovery of notes that Madison had written about the Second Amendment. Right? Gun regulation was not a brand new thing. The D.C. law had been on the books for decades. We had some Second Amendment jurisprudence, including some Second Amendment cases from the court, and I'd be happy to be correct on this, I don't think that there had been a single Second Amendment federal case, federal court striking down a law on Second Amendment grounds for 200 years. Which I emphasize not to say that Heller was wrong, but just to emphasize again the barrenness of the field that Glenn and others had to sow when they were writing their scholarship, and the magnitude of the mountain that Allen was climbing when he won this case. Because, and again, I could be wrong with this, I know one Northern District case in 2000 overturned, it was Emerson, overturned by the Fifth Circuit. I don't know of any federal cases, at least, on overturning laws on Second Amendment grounds. So what was it in 2007, 2008 that gave us Heller so that we're here today on the 10th anniversary?
Okay, I'll start. Well, let me start with this. Well, for much of our history, we didn't have any federal gun laws. And so in a regime where the Bill of Rights was understood since the 1830s to only restrict the powers of the federal government and not the states, state gun laws were not challenged under the Second Amendment. There were state gun laws challenged and struck down, from time to time under state right to bear arms provisions, state constitutions, and that is not an empty field by any measure. We were able to argue based on a lot of 19th century state constitutional analogs, cases decided those. But we didn't have any federal gun laws to speak of, and the Bill of Rights didn't apply to the states. When the 14th Amendment was ratified, we saw almost immediately a Second Amendment case come before the Supreme Court. There was a Second Amendment allegation in the criminal complaint in Cruikshank, in U.S. versus Cruikshank, which arose out of the Colfax massacre in Louisiana, where essentially the Klan overran a courthouse when they didn't like the outcome of an election that installed, anti-Klan forces. And the Justice Department indicted the perpetrators of this massacre for violating the First and Second Amendment rights of the people defending the courthouse. And of course, the Supreme Court then, following the execrable decision earlier in the slaughterhouse cases, said, well, the First and Second Amendments, these are rights that don't come out of the existence of the federal government, and therefore, you can't file the laws, you can't charge people under the 14th Amendment through the Second Amendment. It wasn't until the very end of the 19th century that we got one right, I think the Takings Clause, right, incorporated as against the states. It wasn't until the 20s that the First Amendment started coming in. I don't think it was until 1960s that the Supreme Court struck down, I think it's a religion case under the First Amendment. So it's just we didn't have the history for it. Why did it happen in 2007? The Emerson case was a big factor. Also, all the scholarship that was done on the Second Amendment throughout the 1990s, Glenn alluded to some of that. We saw the scholarship well up. We saw the issue percolate in the legal academy, and then that broke through in Emerson, which created a circuit split, and that's what caused my colleagues to see the issue as one that could be live for the Supreme Court. Clark Neely and Steve Simpson, then at the Institute for Justice, said, wow, this split will be resolved eventually. Let's try to resolve it now with a decent case, and they were able to put the case together. I came in towards the tail end of that formative process. But that's why you saw it then and there. We just didn't have a base for a decision for many years, and once we got a circuit split, it actually came up pretty quickly.
Glenn, did you want to look like you were going to say something?
Well, I mean, a couple of things that I find interesting. Since I teach constitutional law and all, I always talk about how, leading up to the Brown case, Thurgood Marshall, and really before him, Charles Hamilton Houston, spent a good 20 years litigating peripherally related cases to close off the Supreme Court's lines of retreat before they ever actually got to the core question in Brown. And even then, now of course, defeat has 1,000, victory has 1,000 fathers. And so after they won in Brown, everybody thought it was a great idea. But in fact, before Brown, was decided. It was super controversial even within the civil rights and the black communities. A lot of people said, you're ahead of the game, you're too early, if we lose, we're screwed. And we had a very similar dynamic with Heller. There were a lot of people, including actually the NRA, who did not want this case brought in. They thought it was too early and that it was going to lose. And I have to confess, I looked at it and said, well, I can count 4 votes, but I don't feel comfortable saying I can count 5. And that's why Alan Gore is Alan Gore, and I'm me, I guess. But you never know. I mean, another example I use with students is when they brought Bowers against Hardwick in the 80s, the gay rights lawyers were like, well, you know, we can count 4 votes, and we think we can pick up a 5th, and honestly, we think Reagan's going to appoint more justices, and you know, the court's going to get more conservative. This is our best shot for 20 years. They brought it, and you know, they came really close. And then later, Powell said, you know, I think I got that wrong. I should have gone the other way. And if he'd done that, they would have been geniuses. So, you know, sometimes you do just sort of roll the dice on these. If it's an easy case for the court, you may not need to bring it at all. But I also think that the scholarship did provide some pressure, and there was also popular pressure, and I forget which law professor it was. Was it Michael O'Shea who had the thing, said the question the court has to face is, how can you say there's a right to abortion and a right to birth control when those aren't in the Constitution, and say there's not a right to bear arms when there is something in the Constitution? How can you say that as a court and have any legitimacy with the public at all? And I think that question was being asked sharply enough that people could no longer be distracted or fobbed off by saying, well, Warren Berger wrote in Parade magazine that the Second Amendment only protects state armies. You know, that just wasn't going to fly anymore.
I have a little bit different perspective
Shocking.
on how this happened. I mean, clearly, there was a concerted effort to pack the law journals with articles that were critical of the consensus judicial view that had prevailed for many years. Not all of those articles were funded by the NRA, but a lot of them were written by NRA lawyers. Very few historians were entering the fray, and I got to tell you, you know, being on the other side of this issue, we were concerned about this, just because the sheer number of these law review articles, many of them, they quoted each other, they all repeated the same thing over and over again, and they were all a grievous distortion of the history. The problem was that we had a heck of a time getting historians interested in this, to enter this fray and to, as professionals, and to draw into question some of the historical analysis that was populating the law journals. Paul Finkelman did enter the fray, a few others did, but it's very difficult to get academics interested in writing articles that basically conclude the courts have had it right all along, particularly historians on law faculties. And then you had an article that appeared that gets not as much attention as it should. People talk about, you know, Larry Tribe writing on this and Akhil Amar. But shortly after I joined the Brady Organization, 1989, Michael Kinsley wrote a piece for the New Republic in which he said we ought to start thinking seriously about the Second Amendment. And that was, you know, it's a liberal journal. He's a very respected columnist, one of my favorites of all time. And for him to give this view credibility exacerbated the problem. And yet we still had trouble getting historians to enter the fray. The other factor here is that the lower courts, when they were deciding Second Amendment cases, framed the issue in a way that wasn't very helpful, because they would say things like, oh, the Second Amendment guarantees a state's right to a militia, which appeared to be contradicted by the plain language of the amendment, which guarantees a right to the people. And so you had, you had lawyers like Don Cates and others pointing this out, when in fact, the militia view of the Second Amendment never depended on the assertion that it was a state's right. The question was not whether it's a state's right. It is the people's right. It says so. But what right is it? Is it a right to have a gun in connection with participation in organized militia or a right to have a gun for other purposes. But the lower courts were framing the issue in a way that made it very easy to refute that claim. That argument was central to a lot of these law review articles. And it wasn't until the historians got involved and explained the legislative history of the Second Amendment, that it was very clear that these articles had completely distorted it. But nevertheless, that's where we are, and it's an interesting study in how an interest group and an ideology can basically use the law journals to make what was considered to be a marginal argument into a credible argument.
So I can see that there are going to be responses to all the panels, so I have things to say to one another about this, but I don't want to take too much wind from the sails of tomorrow's history panel with Professor Finkelman and Professor Malcolm. And I don't want to necessarily relitigate issues involving articles that probably not everybody here has read, although I will echo what Alan said earlier, that if you haven't, I highly recommend just rereading Justice Scalia's opinion, Justice Stevens' opinion, so you can get a sense of what's out there. But I would like to ask a scholarship follow-up question, because I think one thing that Professor Reynolds said that's so important here is the influence really does seem to be there in the opinions. And one way to measure this is just look what the justices cite. So in Heller, the justices cite more secondary sources in scholarship, and they cite it more often than they do all traditional legal materials combined, that is statutes, constitutional provisions, and so on, cases, right? That just empirically speaking, the influence seems to be there. So I wonder today, when you're looking at sort of the field today, do you still have the same sense that it's as barren or as partisan or as riven? There are innumerable stories of discredited scholars, whether historians, whether it's Michael Galil, whether it's empiricists whose work can't be reproduced by others. This is something often said about John Lott's book, More Guns, Less Crime, which other empiricists have said, we try to replicate the results, we can't do it. That's been suggested to discredit him. And Alan, in particular, you said earlier in your remarks that you believe pretty strongly in the court's or the law's translation function, and its ability to translate history, for example, into doctrine. So I wonder if you think the same for the law's ability to translate other expertise, whether it's policy or otherwise. If John Donohue's right and loosening concealed carry laws or public carry laws raises the murder rate, is that something that law can take up because it's as sort of clear and straightforward? You can read the numbers as well as you could read history. So a general set of questions about the role of scholarship today, in addition to the lead-up.
Well, I think that's a different question. The question of whether or not guns are good or bad for society, and whether John Lott is correct or any of his critics are correct, Donohue at Stanford, that's a question for legislators to determine. That's a question for policymakers. That's a question for the people, because at the constitutional level, this debate has been constitutionalized in a certain direction. So if you believe that guns are essentially a social evil and they create a lot more harm than good, and this has been proven empirically as far as you can take it, then your mission is to convince the political process to change the Constitution. Because the Constitution, if nothing else, is a set of political values. Everything in the Constitution is controversial. There's nothing unique about the Second Amendment. We have debates all the time. We can have debates about whether we should have the police limited by the Fourth Amendment, for example. We'll catch a lot more criminals if we do away with all of the limitations on police and prosecutors. Maybe we can do away with the Eighth Amendment and people will think twice about committing crime. Right? We can have all these empirical arguments, and arguments about social costs are made all the time. But the Constitution, for good or bad, has set out certain policies. And if you think those are bad policies, then the First Amendment guarantees you the ability to debate that and to participate in the political process. But I don't think that it's for the courts to say, well, the framers said, the law should be a certain way, but a bunch of people at the faculty lounge have decided that's a bad idea, so we should let the faculty lounge have its way. That's not the way that law works, especially not in a democracy. So I think it's the wrong question.
Actually, as an empirical matter, that does seem to be the way law works. So I'm going to have to argue with that. But sure, I mean, there are all kinds of policies. You can argue, and people do argue, that making abortion and contraceptives more available has had negative social consequences. Generally speaking, we don't see that as a reason to overturn Roe. It's not a constitutional argument. You are supposed to overturn constitutional opinions with constitutional arguments, not with consequential ones. Though, you know, as I say, that requires a certain degree of self-discipline on the part of judges that is perhaps more assumed than real. I'd like to sort of spin off on something we talked about earlier, which is lower court resistance, because Brandon Denning's here, and he and I did a very extensive, I guess for law it counts as an empirical project, in which we looked at how soft empiricism, that's right, full of rich, creamy goodness. We looked at how lower courts processed the Lopez and Morrison opinions over an extended period of years. We did several articles on the subject, and I guess one of them kind of gives away the answer. It's in the Wisconsin Law Review. We said, our subtitle was, "What if we had a constitutional revolution and nobody showed up?" Because the lower courts basically read Lopez and Morrison and said, you know, these opinions, if we took them seriously, would require us to strike down a lot of federal laws, and so we're not going to take them seriously. And some of them were really quite upfront about that. And the Supreme Court told them twice, we meant it. They said it, and then they said we mean it, but then the Supreme Court didn't do it again, so they ignored it. Are we there with Heller and McDonald? They told them twice, and now we're waiting for the third time, and maybe it's Justice Breyer's third revolution instead. I don't know, although some of you have probably seen it. If you're on social media, there's a meme. It has a picture from the TV show Archer, and it says, "Do you want more Trump? Because this is how you get more Trump." And in fact, I think the election of Donald Trump is in part a response, not specifically to courts ignoring the Second Amendment decisions, but rather to us, really to what sort of I'm talking my book again. Imagine that in an academic. Sort of the class war we have going on in America between kind of the Mandarin class that runs government and academia and a lot of other stuff, and the working in other parts of flyover America, I guess you'd call it. And I think that that resistance is ultimately, you know, if the judiciary fails to pull it off, it's going to be very destructive because, and even if it does pull it off, it's, I think, going to be fairly destructive for the judiciary because ultimately its main resource is its credibility, and I think if people don't trust it anymore, it's much weaker.
Yeah, I'd like to comment on this notion that both Alan and Glenn have articulated, that the problem here is that the lower federal courts are simply not enforcing Heller. They're just ignoring it. They're being renegades. And I think that notion is premised on a particular reading of the Heller decision that I don't think is a valid reading of the Heller decision. The Heller decision that the other two speakers are envisioning is a decision that could not have attracted 5 votes. The opinion that did attract 5 votes contains some very, very powerful dicta. I will acknowledge it's dicta, but among the most influential dicta, I think, in the history of our constitutional jurisprudence. And that is the dicta that actually narrows the scope of the Heller decision itself. And we'll talk about this more tomorrow. And recognizes that just as the court found that there was a historical tradition guaranteeing an individual right to bear arms, there was also a rich historical tradition of restrictions on that right in the interest of public safety. In other words, the 5 votes were assembled to support an opinion that recognizes that not only is there this right, but it is a right that in and of itself creates sufficient threat to the public safety that there is an equally long tradition of regulating the right to try to protect the public from gun violence. And so the lower courts have been applying that Heller opinion, the Heller opinion that actually attracted 5 votes, and that signaled to the lower courts that you cannot enforce this opinion the way we wrote it without recognizing the inherent threat to public safety from the exercise of this right and the inherent power of our elected representatives to regulate the right so as to minimize the risk to public safety. So it's a different Heller opinion than is envisioned by the other two speakers.
Can I briefly respond? Okay, if I can just briefly respond to that. I'm going to disagree with that, unfortunately, Dennis. I don't think that the courts are applying that paragraph of which you speak. When Heller came out, there was this paragraph about certain presumptively lawful, long-standing restrictions that tell us about the scope of the right, and the Supreme Court gave some examples. And Dennis Hennigan's organization said, aha, see, it's not so bad. We've got this exception, this list of exceptions that's going to make everything okay. And it was controversial. People, thought maybe this was, we don't really know. None of us were in the room. We don't know whether this is required to get so-and-so's vote or not. But what I can tell you after 10 years of litigating in this area is that paragraph has not actually been all that consequential. The only thing it's really done, it's disposed of a lot of the facial challenges to felon disarmament laws, and I'll talk about that more in the panel tomorrow. But it has for sure not solved the question of felon disarmament because that word presumptively is there. I don't want to discuss the paragraph. What I would like to tell you, though, is how we're going to make a list of the 5 or 10 worst Second Amendment decisions in the wake of Heller that totally ignore the opinion and are essentially fabricating law. That paragraph doesn't feature in them. It's not really been where the courts have gone off the rails. And in my view, if you look to see how the courts evaded Heller, they've reduced everything to interest balancing. They have applied essentially rational basis review, whether they call it intermediate scrutiny, or as we saw in one of my cases a couple weeks ago, strict scrutiny. It's a rational basis case, don't be fooled. I mean, this is what we've been reduced to. There's this magnetic, unyielding attraction of courts to shove every single thing into interest balancing and apply some standard of review. And that, of course, is extraordinarily empowering to judges because regardless of what standard you claim to be using, you can always cook the result to come out the way you want. And that's what they're doing. One of the striking things about the Wren decision, which in the DC circuit that got rid of the May issue carry law there, is that it approached the question in a categorical sense. Like this is a destruction of the right. So we're not going to get to interest balancing. This is simply the law is incompatible with the regulation that you have here, which was, of course, the way that Heller itself came out. And I say it until I'm blue in the face, but judges don't care. Heller didn't use interest balancing. Heller simply said the amendment means a certain thing. These rules are incompatible with it. We don't need to get into construction. But judges want construction. They don't care about that paragraph too much. Sometimes they do, but usually they don't. They just balance everything into oblivion. That's really been the problem.
So let me ask one more question, and then I want to open it up. Because what Alan's describing here is the debate about whether Heller is essentially being overturned in the lower courts. We can have a debate about that. But you all also talked about, and Dennis was in your comments and Alan yours as well, the idea that Heller itself would be outright overturned by a future Supreme Court. And I just want to revisit that, because I think I have a different take on this. I think maybe than both of you. One thing that was remarkable about Heller when it came out was this was in the middle of a presidential campaign. Both Obama and McCain immediately came out and said they supported the results. 75% of Americans support the results. The political parties, Democrats and Republicans, have both said they endorse the Second Amendment, support Second Amendment rights. It's not like Roe that way. It's not like Citizens United that way. I mean, if you look at the platform speeches that are given at by the Democrats or Republicans, they have Supreme Court decisions in their sights. And I haven't heard that about Heller. And even on Garland, there were allegations made about his votes in Parker and a few other cases that he was going to be an anti-Second Amendment justice if confirmed. But the people who supported him, if you thought that's what they wanted, you might have thought they'd embrace that, and they didn't. They all said, no, that's wrong. He's not an anti-Second Amendment justice. They pointed out, Judge Randolph voted with him in the Parker vote, which was just to go in bank. It wasn't, to necessarily to overturn the case, which, given its significance, you could say is not necessarily a merits vote. So I guess I wonder, Dennis, it sounds like you kind of came around to this at the end, that there's no major, that I've heard, push for Democratic Party or from, which is where I would assume it would come from, it came from a party, or from any of the gun control groups. So where would that come from? And do you see it likely anyway?
Well, I think the situation would have been different if in the wake of Heller, lower courts began to strike down gun laws, and they did not. And it was in fact, I think, the dicta about of the long tradition of presumptively valid gun laws that was immediately latched onto by the lower courts in upholding gun laws that were under attack. And I think the situation would be radically changed, and I think the gun control groups would in fact rally against Heller if there was any reason to believe that the Heller was becoming a potent weapon that was going to begin to unravel our gun laws. And so, you know, the last chapter of this story has not yet been written. And I certainly was appalled by the Wren decision. I was shocked that there was no en banc review of the Wren decision, but it's that kind of decision. I mean, if you had Wren decisions popping up all over the country, striking down not only carry in public laws restrictions, but other kinds of gun laws, I think you'd see a different dynamic towards Heller. But the way things are going, I think Heller's here to stay.
Well, we're working on it, Dennis. You know, doing the best that I can, okay? It's not easy. We've seen a very smart strategy from the other side in not sending things to the Supreme Court when they lose. And they have lost a bunch of cases, they just don't petition for cert on those. And that's why you can now carry a handgun if you want, go through some hoops, but you know, everything in Chicago and Washington, D.C. has hoops in it. I always tell people, look, if I can make guns as regulated in Chicago as everything else is regulated in Chicago, that's fantastic, you know, from their point of view. I mean, it's not a place that has a lot of freedom, generally speaking, in other facets of life. But where would this come from? I think it would come from the culture of the judges and their belief system. And it doesn't matter what the Democratic or Republican parties say about Heller and their platforms or what they don't say about it. The hatred and derision and hostility of these judges to these decisions is palpable. I've been before them and I've felt it and I've seen it. And a word about, you mentioned Judge Randolph, you know, I believe a Reagan appointee or a George H.W. Bush appointee, Republican appointee nonetheless. Karen Henderson also on that court, Republican appointee. The most strident opponents of Heller that you might find, I think. These are not judges that, you know, any gun rights advocate would love to see in a case in the D.C. Circuit. Ask me how I know. But that brings me to something else. There's I think, a misconception out there that, oh, this is all, you know, if we get Republican judges, they'll vote one way, and if we get Democrat judges, we'll get a different decision. I'm not sure that's true. We get, I mean, I haven't done the math, so this could be wildly wrong, but, you know, anecdotally speaking, my back-of-the-envelope guesstimate is that we get, you know, a few, occasionally we'll get the votes of somebody who's nominated by a Democratic president. We might get 50 or 60% of the Republicans, okay? So you can do the math. It's not great. I can think of any number of Republican appointees who are as hostile to this right as anyone that you could name. And they're not going to turn up in the vote for enforcing Heller in any way ever.
And country club Republicans, not gun club Republicans.
I don't know what country club they belong to, or if they belong to a country club. I don't belong to a country club or a gun club, so you know, I'm at the Y. I don't know if that, you know, and I don't see any judges there. I'm in Alexandria, no, it's definitely I think a cultural problem, and they hate this decision. They'll get rid of it, and they don't care what what the politicians say. When they are there in that conference room and they're taking a vote, when they get to 5 votes, this thing is gone. And I would bet all the money in the world, especially if it's in your pocket, on that. Thanks.
All right, with that, I'd like to open it up for questions. Any from the audience? In order to pick up the audio for the videos here, we have a roving mic. So if you'd like to ask questions, I'm happy to keep asking. I've got a lot. But if you'd like to ask, please raise your hand. And we have a mic circulating right here. I see a question in the middle.
So long, the pressure's on now. That was quite a build-up. Can you hear me? There we go.
It actually won't amplify you. It's just for the purposes of recording, so we just kind of keep it low. I think
Okay.
that's what they explained to me anyway.
All right, essentially, my name is Paul Vallone. I direct Grassroots North Carolina State's primary gun rights organization. In 25 years, it has dawned on me that it has become popular in this debate to say that a school of thought or a person's work is somehow wrong or discredited without actually saying what's wrong or discredited about it. I have read Joyce Lee Malcolm's To Keep and Bear Arms, Origins of an Anglo-American Right, and by all accounts and by all appearances, it's extraordinarily well documented in terms of documenting the intent of the framers in drafting the Second Amendment. So my question to you is, you have said that the history behind Heller is wrong, or that it defies reality. I realize we're kind of limited on time here, but what's wrong and what defies reality specifically?
I think that one's for you, Dennis. My impression.
Well, I'm just going to barge in and answer it.
I should, by the way, just plug again the panel tomorrow involving Joyce Lee Malcolm and Paul Finkelman, where some of this will come up again.
Yeah. Well, the fact of the matter is, if you analyze the legislative history of the Second Amendment, which I think is the most directly relevant historical material, you see that the debate the framers were having was entirely about the militia. It was not about the need to ensure the right to self-defense at all. And I'm not going to go into. I mean, I've written quite a bit about this myself. I've done my own law office history, I have to confess. As Glenn said, I was one of the few writing about it during this early period, although not as early as you think, Glenn.
It's the 40s, right? When you started?
Right. You had me at the 70s, now the 40s. I wrote the Miller decision, let's face it.
Justice McReynolds.
You were
1930s,
clerking.
anybody not following along?
Here's a McReynolds clerk, yeah.
Right. And I got to tell you, when I first started working on these issues, and I thought, well, I gotta look at some of this original historical material myself, and I expected to find that, well, geez, all these colonial leaders, I mean, they liked guns, they carried guns around. I'm going to find that guns were highly valued by the framers of the Constitution, and we're going to have to figure out how to make some kind of argument based on contemporary circumstances. We're going to have to diminish the significance of the history. And then I started reading the actual debates in the first Congress and in the ratifying conventions of the states, and I realized, my goodness, actually, this is about the militia. And most of the historians, by far, who have looked at it have concluded the same thing. For example, I'll just give you one example from the legislative history. Madison's original draft of the Second Amendment had a conscientious objector clause. Now, if his intent was to create a personal right to be armed, divorced from militia service, why would it ever occur to him to put a conscientious objector clause in the Second Amendment? Now, it didn't survive. It was actually taken out because those who were supporting the Second Amendment thought that it would serve to weaken the militia, but it was all about the militia. So that's just an example of the kind of historical fact that is largely ignored by much of this pro-gun writing. As far as Joyce Malcolm's work, I would recommend that you read the work of Lois Schwerer of George Washington University, who is probably the leading authority on the English Bill of Rights of 1689, which pro-gun people say is the progenitor of the Second Amendment. I'd suggest you to read some of her work because she does a pretty nice job providing the other side to the interpretation of the English Bill of Rights.
I'd just like to jump in with a question because, militia discussion seems so old hat now, but since we have it, when the Second Amendment talks about the militia, it says a well-regulated militia being necessary to the security of a free state. Now, I think it's beyond dispute that we don't have what the framers regarded as a well-regulated militia in any sense or form. And does that mean that what we have right now is unsecure and unfree? And if you believe that, and if you believe that the militia clause of the Second Amendment has force, isn't the federal government in default on its Second Amendment responsibilities? And if the federal government is in default on its Second Amendment responsibilities, what's the remedy for that? One remedy might be self-help by people arming themselves, since they can no longer count on the government to maintain the militia that the Second Amendment says is necessary to a free society. Just a thought.
Question from the audience, from a historian, no less.
From a historian, yeah, I want to suggest to Glenn, and I want to respond to that in this way, which is that the Second Amendment says that a well-regulated militia is necessary for the security of a free state, and that the states have the obligation to maintain a well-regulated militia if they choose to do so. The federal government in Article 1, not in the Second Amendment, has an obligation to arm those militias and to have set up uniform rules for the militias, etc. Now, the history of the militias is pretty clear. Militias exist in most states until the Civil War, although, for example, Delaware did not have a militia in 1860. And since the Civil War, most states have voluntarily abolished their militias and instead have accepted the National Guard, which functions as the state militia and is the functional equivalent of the state militia, although some states, such as Texas, still maintain its own state militia. So it's not the federal government that would be in default. The federal government made an offer to the states. We'll take over the whole thing. We'll have National Guard. And if you like that, then you can opt in. Or you can have, as Texas does, both the National Guard and the Second Amendment, and the state militias. So I don't think there's
Well, of course, we got the National Guard primarily because the state militias of some of the southwestern states refused to invade Mexico, and Attorney General Wickersham opined in 1912 that they were within their right to do so because the militia can only be called out to resist invasion or suppress insurrection, not to invade other countries. And lo and behold, we instantly get a force that we can use for foreign adventures. So I would suggest that the National Guard is absolutely, no, sorry, but the National Guard is absolutely not a substitute for the militia at all, but is rather an effort by the federal government to create a new body which is, from its standpoint, more subject to control than the militia contemplated by the Second Amendment was.
Glenn,
Yes,
can governors call up the National Guard?
unless it's been federalized.
I mean, I'm not asking that. I mean, a straight yes or no.
Yeah, but
May the
as-
governor
as-
call up the National Guard?
Yes, and when they do, they are calling up a body of troops. They are not calling up a militia. It is at best, as Akil Amar said, a select militia of the sort the framers thought was dangerous because it was too easily turned to political control of the populace.
Well, we can, I mean, this is a debate.
Yeah,
that we
it is.
that we could have for a very long time, and we could burn many trees in the process, or at least pulp them into paper. My only point is that functionally, in the 21st century, the National Guard functions as the state militia does. It is the first armed body called up in case there's a crisis. It is the armed body called up if you have a non-military crisis, such as a flood or a fire. And it is regulated by the national government under Article 1, as Article 1 says it should be. And I think it's if you would like to see the state militias recreated, then you need to go to the North Carolina legislature
So
and
it
say,
sounds to me you're saying
but
then
it's
that-
not the federal government.
Let's have just the elastic change on this one only because I see we only have 8 minutes.
I think
I want to make sure we get lots of questions.
questions.
That's fine.
Go
The federal government did not abolish the state militias.
I think you're saying that the
If
state's
everybody's
right
not
here.
at the historical panel tomorrow, I'll be disappointed. Clearly a lot to discuss here, but there's also only a few minutes remaining, and I want to make sure we get in any other questions. More questions? About the militias or otherwise, in the back there.
There's been a lot of discussion about lower courts not wanting to go along with this and enforce what the Supreme Court ruled. The Supreme Court presumably could say, come on, this is the way we rule, we're going to take another case and say it again. Have you gotten a sense of why the Supreme Court has basically washed its hands and said, we've done what we're going to do, we're not going to say anymore?
No, they don't tell us why they don't take cases. We don't, they usually don't give us that level of insight into their reasoning. All we know is that is what we see, which is that they're not taking cases, which are ever more ridiculous in their outcome and reasoning. And there are a few justices who are calling out the unreason of this process. But what you see is what you get, right? I mean, the court is obviously okay with it because it's unwilling to do anything about it. And I think we're beyond the point of being concerned solely about Second Amendment doctrine or the state of gun rights. I think that this is very concerning as a matter of having operational vertical precedent and maintaining the court's credibility with the public. They're not fooling anyone. I can tell you the people I interact with out there in America are losing faith in the competence and willingness of the federal judiciary to preserve their rights and to hear serious cases.
Just on the larger question, and this is much beyond the Second Amendment, it is absolutely the case that the Supreme Court provides virtually no supervision to the courts of appeals in general. And I actually did some research a few years ago on the number of cases that came out of the courts of appeals, and I'm going by memory. This is roughly correct. I think in 1973, I think it was 770 published opinions from the courts of appeal. And in 2008, or whatever it was, I did the research, it was like 30,000. Meanwhile, the Supreme Court actually takes half as many cases. So even in terms of providing broad policy guidance, and particularly providing broad policy guidance and then making it stick if the lower courts resist on any of a number of subjects, the Supreme Court's just not maintaining any kind of significant supervision of the courts of appeals at all anymore. And that is a much larger problem than anything they do about gun rights.
One brief comment. I think that the question really goes right to the point, which is that, if the lower courts were acting as renegades defying a Supreme Court decision, why hasn't the Supreme Court granted cert in one of these cases? The fact of the matter is that the Heller opinion that attracted 5 votes is the opinion that this current Supreme Court is enforcing, and they could clearly correct what the lower courts have been doing. They could put them on a different path. They could create a whole new precedent. They have done none of those things. Again, the pro-gun folks are imagining a Heller opinion that was never written. The lower courts are actually being loyal and recognizing the validity of the Heller opinion that was written.
I want to make sure we get in, does everybody have one chance on that question, and then I see we've got at least one more coming from Brandon Denning.
Dennis, the one decision that has come out of the lower courts that I think disproves your thesis is Moore versus Madigan. Richard Posner didn't have to write the opinion that way, striking down Illinois' ban on public carry, and yet he did, because he said, I'm pressing Heller's logic to the limit, and I submit that was bait that he was throwing out, trying to get the Supreme Court to take up the case and either narrow it or overrule it.
Well, I agree. I think that's a fascinating opinion, and it's one that deserves some thought. Part of me thinks that, Judge Posner is the judge who said that Heller was a massive snow job. So he thought Heller got the history completely wrong. And, he's even more extreme, I think, in denouncing Heller than my old con law professor, J. Harvey Wilkinson. But I almost think that part of what he was doing was saying, you got it so grievously wrong, and now look at what you're making me do. I think that in his mind, what he did was a principled application of Heller. I think that he is very much in the minority in that view, although he attracted a majority of that panel, obviously. you know, other circuit courts have not found in Heller a requirement that this right be extended beyond the home. He read Heller differently, but I think part of this is him saying, you know, you're making me do this, what I regard as an opinion that was not required by the Constitution at all, because the court originally got it all wrong.
Let me ask one last question that I hopefully will pick up on Brandon's and bring together a lot of the themes that we've engaged today. And we can start with Moore, because this is a case that's come up a few times. Seventh Circuit case involving a statewide ban on public carry. And my recollection of this, and you guys who are familiar with it may correct me, that was the only state that had such a law, right? That Illinois was the only, it was an outlier case, it was an outlier law. And I wonder how that maps on to what we've been saying about judges and their relationship to the Second Amendment or to gun rights and gun regulation generally. Because if it's true that they're so far out of step, they're not in a position to do much harm unless the people are also out of step and vote in favor of laws. Because the judges can't pass them, they can only strike them down. So unless the American people, and maybe the answer to this is just they are in certain areas, biased against the Second Amendment in the way that you think judges are, then there shouldn't be problems that the judges would ever be in a position to fail to correct by their biases. I wonder if you think that's true.
Well, Democratic majorities are always out of step with the rights of people who dissent and want their rights enforced. I mean, the whole point of having a constitution with the rights that you can get enforced is that you lost the election, the legislature's against you, they're trampling on your rights, and some neutral judge applying an old but still applicable principle of law is going to override the political judgment. If you take the view that, well, people are voting for this stuff, so there's no problem. I mean, I suppose there are people who have that view. I'm not sure it's the system of government that we have. So in fact, we do have large areas of the country where there are a great many gun laws that you could never imagine any of them being struck down. Let's look at the Ninth Circuit, for example. I mean, this is a court that's gone en banc over and over and over again to undo the work of any panel that remotely imagines there to be some kind of a Second Amendment issue. This is a court that covers a very large fraction of both the landmass and I believe a fifth of America's population. It has some jurisdictions that are intensely hostile to gun rights. Never has the Ninth Circuit seen a single Second Amendment violation, either facially or as applied, at the federal, state, or local level anywhere, as it's applied to that whole region and population. No, I mean, obviously there's something else at work there. And you know, we can ask ourselves, you know, how many gun laws have been struck down? There have been a few, but you know, is it really the case that magically all these years the federal government and the state governments have been operating without the benefit of a true understanding of the Second Amendment, and they somehow got it right the whole time because they never managed to violate the Second Amendment? Or is it that, you know, the courts are simply unwilling to enforce the right? I think it's the latter view.
Spencer, did you want to offer any closing remarks, or should I wish everybody a good evening? We made it until 9 o'clock.
Thank you all for coming, and I look forward to a great program tomorrow.
Please join me in thanking the panelists.
Okay. Good.